session. Where there's a will, there's a way. Jason Roccasalvo is my name, partner in TAG's Superannuation Advisory and Audit Division. With me today is Emma Partenza, the manager in the team. G'day, Emma.
Hello.
As with all our sessions today, please feel free, if you've got questions throughout, to type them into the chat box there. G'day, Yvonne. Pop the questions through there. As they come through, we'll endeavour to answer them while we're presenting. If we run out of time to be able to get through all the questions, then what we'll do is we'll convert that into a blog and get that out to all of you in the coming week or two after the session. But what's really important with sessions like this is if you've got questions, you're probably not the only person thinking it. So make sure that you ask it, because there might be others that are perhaps a little bit gun shy. Obviously, the information in here, we've got a little case study in here, which we like to use to sort of show the importance of an estate plan and thinking things through clearly. But the information in here obviously is general in nature only, shouldn't be applied to your circumstances. With everything with an estate plan, it's prudent to get the proper professional advice at the appropriate time before acting on any decisions. So what are we going to cover today? So, we're going to look through things like what your will can contain and what it can cover and what it doesn't cover. Okay, so there's often a few misconceptions there. Just because also something isn't covered in the will doesn't mean there are ways that we can try and still protect it and effectively get the result that you're looking for, I guess, as a will maker. We're going to look at protecting wealth, which is obviously a primary concern. Something that's often misunderstood, which is the managing of the tax issues. We'll obviously go through estate planning issues within super, which is a really important part for people to consider, particularly where, most people have their family home in their super. So it's the second biggest asset that we've got for most of us. So making sure that we're planning effectively within our superannuation, whether it's a self-managed fund or otherwise. We'll go through some of the most common estate planning questions as well. And then we'll also talk about, obviously, from it all, the overriding theme is the importance of reviewing your estate and having that estate plan. So, when we think about estate planning, what does estate planning mean? Well, in a simple context, it's a plan to make sure that the right people get what you want when you're gone. Okay, so that great estate plan will preempt those issues with beneficiaries, making sure that those beneficiaries get their entitlements in the right way, and also a way that's suitable or appropriate for them, because there's nothing in life is simple. There is a lot of complexities that we've got, not only in your own lives, but the lives of those around you. So it's really important to consider that. Obviously, tax effective distribution is really important. Obviously, as accountants, that's something that we're keen on minimising for everyone. So it's really important to consider that, because tax consequences not contemplated can lead to different outcomes. So that's really important to consider. And probably the most unappreciated part of it is an ease of management of the estate. There really is that balance between great ideas and what we want people want to achieve, and then making sure that it can be achieved, it can be implemented by the executors of the estate, it's understood by the beneficiaries and those sorts of things. It's really important to have that ease of management, because we can get caught up in trying to achieve too many things, but make it so complex that people don't know where to go or what to do. So that ease of management is really important, and typically comes in its best context by actually contemplating it beforehand. It always surprises me, but doesn't surprise me that half the adult population don't have a will. So the making of the will is as a result of formulating and having that estate plan. Okay, so it's in a estate context, the will is like the choosing of your investments, but you need an investment strategy and investment plan before you actually go and start picking your investments. So that's sort of how those two should work. I'll hand over to Emma, who's going to go through how to create a successful estate plan.
Estate plan. Thank you. So as Jason said, we're always thinking about, I guess think about with the end in mind, to get us started here. So um, very important, with potentially assets going to particular beneficiaries. They may or may not be sold, to liquidate the estate to pay cash through, or distributing the actual asset through to the estate onto the beneficiary. At some point in time in the future, it will be sold. So we need to make sure that we're recording cost bases, because they essentially carry forward through for the beneficiary. So record keeping, ownership details, having all of those, important documents in order and in a specific place. The executor knows exactly where they are, and that type of thing. It's very important to educate the next generation. So, a lot of clients now are having conversations, with their executor, with their kids, what their wishes are, why they've structured their estate in such a manner. Um, you know, what happens if I get really sick? Do we, do something with the fund before, to save taxes before that sort of time? So everyone knows exactly what your wishes are, can be followed. Again, as Jason said, it's easy to execute, and that sort of thing. You've worked hard, um, obviously, to your to achieve your wealth and generate your wealth and maximizing your wealth and that sort of thing. And if you're leaving a legacy, you're passing it on to the next generation. So obviously you don't want them to swindle it. So all of these things, you're contemplating in a successful estate plan. So it's passed on how you want. And tax planning might be a consideration, or not for most people. So just when we're distributing specific assets, it's important to keep that in mind, because that can potentially change if want something to go 50-50. Tax implications can change that, and somebody might get less. So it's thinking about all those things and just being open, honest, and communicating with all the important people, as to your wishes. Um, the the last point there, picking the most appropriate executor. So a lot of people might sort of choose children, or one or two children. They can act sort of jointly, or um, that sort of thing. I think the things to be mindful of is if you've got like a solicitor or a lawyer sort of acting, are they a similar age to you? Have they not, are they still around? Maybe they've retired, their age, that sort of thing. The same happens to friends. If you wanted, a really good dear friend to act on your behalf, same sort of thing. Similar ages, do they have capacity or the capabilities to help? There might be health issues and things down the line that they're not able to act in that capacity for you, but let alone would they want to help. So lots of things to keep in mind. So your benefit and wishes are executed by someone who knows and can actually be in a position to deal with that for you. What can you include in your will? So as we said, it's very important to have a plan. Essentially, what you can include in your will is all assets in your personal name. So, you know, personal assets, jewelry, artworks, cars, collections, boats, those types of things, bank accounts, term deposits, all your personal investments, if if they're under my name, and insurance proceeds, etc. Now, your will doesn't include, so you might have a family trust that has a portfolio of investments, for example, other entities, and even joint assets. Obviously, joint assets will automatically revert to the survivor. So, yes, put them in your will, because you don't know which spouse is going to go first. But they're not going to then form part of distributing equally to the three kids, or whatnot. So um, it's critical to sort of have that distinction. So family trust, you're not sort of distributing the assets of that trust. You're really wanting to look at control of that trust and putting in your will, you know, an appointer for that trust, so the trust can continue on, and the control of that can still happen. So yeah, it's important to note those sorts of things that, you know, some people take for granted. Well, they're my assets and they'll be in my will. So now, in terms of super, you can include super in your will, but you don't actually have ownership over your benefits because it's the trustee who owns the assets for the benefit of the members. So in most cases, a lot of you are acting in both capacities. So it's sometimes hard to distinguish the role that you're actually playing there. Superannuation is a trust. So that being said, superannuation is not a personal asset, although it can be included in your will. But if you're included in your will, and we'll talk about binding death benefit nominations later, um, it's not actually automatically an estate asset because you need that binding nomination to talk to your will for your super to form part of the estate, and then it will be included as part of your estate. So tricky one to get your head around. Most people don't realise that. They just think, oh, well, it's an asset of mine, it's automatically in there. But you need to have the right things in place, again, as part of your plan, overall plan, to make sure things work how you want them to work. Jason, do you see any sort of specific or, you know, common challenges in regards to super and the wills?
Look, commonly, I guess the challenge with super, and we'll talk about tax consequences, but the challenge with super, as you said, is that it's not automatically part of the estate, so it's got to be referred to, or it's got to be directed into the estate. So we commonly see maybe superannuation referred to in a will in the context of it being any superannuation that forms part of an estate, making sure that that gets as best as possible distributed to somebody who is a superannuation beneficiary or recipient, so that we can make sure that the tax treatment is the most effective. But commonly, and you know, I'm sure we'll talk about it with the a bit later on as well. Commonly, you've got the challenge between sending it to the estate or sending it directly to an individual. And so, you know, while an estate can be challenged if the death benefit nomination is, you know, complies with everything it needs to, you know, it might make more sense to send it direct to an individual to sort of thwart the threat of an estate challenge, but that may not lead to the best outcomes. So yeah, we commonly see it referenced in there, but if you're not thinking holistically, which is part of that whole estate plan thing, just because it's written into the will, as you said, doesn't necessarily mean it's part of the estate. It's not therefore part of the distributable assets. Therefore, you know, it's not necessarily the most, well, that part of the will might be completely irrelevant. Yep.
I think we're going to look at a case study if we move on to the next slide. So I might just talk a bit about the case study for a minute. So we've got Jack and Diane. They're both previously divorced. So this is their second marriage each. So we're looking at a blended family situation here. Now, Jack runs his own business. And he has other entities, so he's got a family trust that invests. He's got a self-managed super fund and other various personal assets. And his wish is for all of his assets to be split equally, well, by 3, 2 kids and Diane being his spouse. Now, in terms of Jack's business, it's run through a family trust. The assets of the trust are $800,000, and there is a loan from Jack and Diane, a joint loan there, $500,000. He's got joint assets of $2.4 million, and that includes their principal place of residence. Other assets include Jack's given his kids a loan totaling $500,000. Now he has documented this. And in terms of his super, he's got 1.3 million in super. Now he's got a binding death benefit nomination that once he goes, all the benefits will go to Diane directly. And that will also include a $500,000 life insurance policy. So this, at the end of the day, Jack wants all of this to go equally to two kids and to Diane. Um, do you see any issues with this, Jason? Are his wishes going to be met, based on that situation?
Yeah, and this is an interesting one, and it sort of ties in, Emma, to what you were saying before about what you can will and what you can't will, particularly around, the family trust side of things. So,
Mm,
when we actually consider the circumstances, we can look, and it's probably easier to focus on the non-estate assets because there's more of them here. But really, what we've got,
mm,
as you said, joint assets. So really, joint assets. Um, the music stops. It's not Jack's because he's dead. So it, I guess, defers back to Diane as the owner of that asset. So you got the family home. It is in joint names. It goes to the remaining survivor automatically. Therefore, it's not part of Jack's estate. Okay. You've got the family trust, that really what you need to look at with the family trust, it's got $800,000 worth of assets. There's that loan to the family trust. So that's a loan that Jack and Diane have given to their family trust, as it's a joint loan. Again, similar circumstance. So effectively that now is really an asset of Diane's. It's a loan of Diane's now to the family trust, and therefore forms part of her estate. So not part of Jack's. The family trust assets, they're trust assets. They're not Jack's. So they're not assets that are distributable by him in his will. You mentioned with regard to the super fund, so you've got the death benefit
mm,
nomination that's sending it to Diane. He's got some life insurance within the fund as well, so that's going to all form part of his superannuation benefits. And with the binding nomination in place, that's all going to Diane as well. So that, as we said before, doesn't even make its way into the estate. So you've got all this wealth that Jack perceives is his, and none of it forms part of his what is considered as part of his estate. The only thing that is that loan that he has given to his kids for $500,000. So, if his will just says, I want my estate split three ways between my wife, my second wife, Diane, and my two children, what is in his estate? Really, it's $500,000. That's it. Okay.
mm,
And that's obviously not an outcome that, if you're not contemplating or formulating a plan, what you've documented won't be able to execute what you're trying to achieve. So that's why, in a circumstance like this, an estate plan is really vital. Now, you might, what could we do differently here? We'll talk about some tax issues onto the next slide, but, what could you look at differently? So the family home, as I said, it's in joint names. So, well, at least here in Victoria, you could consider changing the ownership of that from jointly held to a tenant in common. So Jack holds one of two shares, Diane holds one of two shares. And what that then means as a tenant in common asset is that Jack has a defined interest, his one share, and that one share or half of the property then would form part of his estate. Okay. So that sort of example adds another $1.2 million to Jack's estate, just like that. Okay. Again, in Victoria, we have between spouses, we don't have any stamp duty on main residences. So that's a good, as title changes between spouses on a main residence. So that's obviously a promising outcome as well, because it's not just as simple, obviously, as just saying let's change the title. If that was an investment property, I don't think you can accomplish that as well without contemplating stamp duty, which is a heavy cost. All right. Family trust. Sorry, before I get on the family trust, so the joint loan, you could look to do something similar. Is that two loans of 250,000? How can that be redocumented so that that's an asset that Jack has, and obviously conversely Diane has as part of her estate. The superannuation I'll come to last, but the family trust, again, we're talking about control. So, it's a family trust. It's running a business in there, which is perhaps a bit more of a complexity because Jack may want that business to be run by his children. Okay. So if that's the case, then he needs to make sure that the children can take over or assume that control of the trust. Right. So they don't get the actual assets within the trust, but they get the control. Now, how do you do that? So a family trust has, like a super fund, they're a trust, they have deeds that basically is effectively the constitution. It's the laws that govern specifically how the trust can operate. Within that deed, a trust also has certain roles. So it has a trustee, it also has beneficiaries, it also has a role which is called typically an appointor. Okay, and that appointor position, what do? Well, they basically have the role or the capacity to hire or fire the trustee. Okay, so really the appointor is the position that yields the ultimate power on who controls the family trust and therefore who controls all those assets. So um, a lot of family trust deeds will also, or discretionary trust deeds will um, have clauses in those deeds as to how that appointor position can be changed and what rights the current appointor has to, you know, refer that position on to somebody else. Okay, so very commonly what we see in discretionary trust deeds is that it allows the appointor to make a nomination of a subsequent appointor on his or her death, and they can make that nomination in their will. So that's the sort of power that we're looking to see in a trust deed. And then what we would, be discussing here with Jack is to make sure that within his will that he confers that appointor role, say, onto his daughters if he wants the daughters to run the business in the future. Okay, or if he wants the daughters to benefit from the assets. Okay, so that's sort of how we contemplate and deal with the family trust. Superannuation, we've touched on before. So you've got the death benefit nomination, it's going to the wife. Typically, that's how we see it, because between spouses, you can distribute on death balances between spouses and not be subject to any tax. Okay, so we're typically seeing the superannuation going to a spouse because we don't have any death taxes attached to it, which is obviously a positive thing. But that may obviously or needs to be balanced up with, Jack having, $5.5 million worth of non-estate assets there and only $500,000 worth of estate assets. Okay, so if he thinks he's worth 6 mil, well, he wants Diane to get 2 mil and his daughters to respectively get 2 mil. So how is he best going to be able to achieve that given the mix and given where the assets are? Diane having the super, there's 1.8 million. Gets complex with the family home as well because Diane's probably going to need somewhere to live. But that's maybe where you consider the ownership of everything. And at least the thought processes can allow you to formulate that plan, which can then allow you to execute it properly in your will, which means the executors, A, know what they're doing, and B, as the individual, the result that you're looking for can be achieved. Okay, so here's an example here where what can innocuously be considered a fairly simple and reasonably standard request, like I want my assets split 3 ways, and you can see what is actually Jack's assets are dramatically different than what is commonly the perspective that you've got. Moving on to some tax issues in estates. So main residences. Generally have a 2-year window. So an individual passes away, their main residence, the estate has 2 years to dispose of it from date of death. Doing so within that 2-year period means that you can continue the main residence exemption all the way through. Okay. Now, if you don't sell it within that 2-year period, what happens there is you basically go back to the date of death, and the value of the asset at the date of death is deemed to be what the cost base of the asset. So when it is ultimately sold, those two numbers are what you're balancing up in terms of your exposure to capital gains tax. So you might have a situation where someone bought a property in 1970. They've lived there all their life. They died they paid $10,000 for it. They died in 2021. The 2 years is almost up now. So selling it now as an estate would be able to continue the main residence exemption. Obviously, it's a pre-CGT asset as well, and I'll come on to that in the next point. But just, that main residence exemption obviously means the asset's completely tax-free. If the estate doesn't end up selling it, then basically what you do is you're taking the value as at date of death. And typically you're going to need that value pinpointed in the probate application that you provide to courts. So when someone passes away, obviously you've got to go through a death certificate. Once you've got the death certificate, gather up the will, you take the will, complete a probate application to the courts. The courts grant probate, and that basically confers the power for the executor to start doing stuff, start dealing with the assets of the estate. But as part of that probate application, you're listing all the estate's assets and the estate's liabilities and their market values. So that's where you'd grab that in the event of someone passing away, particularly around a main residence. Now, as it relates to pre and post CGT assets, here's where it gets kind of interesting a bit more, and more interesting perhaps on things like shares, because property asset, you're not buying a bit of a property there and then dribbling it away on the way through the ownership period. But you could have bought CBA shares when they listed in 1992 or 1993 and participated in dividend reinvestments the entire way through the ownership period. They all have cost bases, they all have acquisition dates, they all need to be known. Okay. Now, whether it's so therefore post CGT assets, we need to know the acquisition date and the cost base. Where an individual has a pre CGT asset, so let's say they bought BHP shares in 1970. What happens to those if those shares get passed on to a beneficiary? Well, their beneficiary is deemed to have bought them again at the value at date of death. So the cost base gets refreshed, so they cease being a pre-CGT asset. And so that's an important thing to understand. Now, I'll come back to the after-tax value of assets. When is tax actually paid? The tax isn't actually paid as it relates to assets of an estate until the assets are physically sold. So the sale of an asset needs to be sold to someone else. But if you have someone pass away and all that's happening is that they've transferred the ownership of some shares from the deceased to a beneficiary, then it's when the beneficiary physically sells the shares, that's when the capital gains tax starts getting assessed. Okay, so it's really important, Emma touched on it before, it's really important to have that sort of data available about cost bases and things, particularly where you see a situation where you might have, let's say a husband passes away, his assets or his cost bases of assets go to his wife. Then, a few years later, say the wife passes away and then everything's getting distributed to the kids. So you've got multiple acquisition dates from the dad's death, transferring assets to the wife if they were pre-CGT values. And then you've got post-CGT acquisitions and things to balance up as well. So there's a lot of complexity in amongst the timing of when assets are bought and when assets have been transferred. So if they were bought initially by someone, then they've subsequently passed away, you can pretty safely bet that the cost base is completely different. So that adds a lot of complexity, and those things need to be considered because multiple beneficiaries may have different tax treatments. They may have different desires with what they do with their inherited wealth, but the after-tax value is what they're really going to need to be knowledgeable on and concerned with. If they inherit a property, then want to sell it because they want to pay off their mortgage, well, they might sell the property, pay off their mortgage, and then, 12 months later, get hit with the capital gains tax bill and not have the liquidity to fund it. So the after-tax values are going to be really, really crucial for people to understand. Testamentary trusts, now they're a fantastic vehicle. The testamentary trust is basically like a family trust or a discretionary trust. The trust is written into the will, okay, but the trust isn't active until the person that wrote the will passes away. So it just basically sits dormant. There's no reporting requirements. There's no lodgement requirements. Someone passes away, and then the trust basically gets activated, and assets from the estate go into the testamentary trust. Now, why are the testamentary trusts fantastic? Well, they're fantastic for asset protection. So asset protection in terms of, say, creditors for the beneficiary. The beneficiary may have their own business. They might be a doctor, be at risk of getting sued. So they want to sort of maintain assets in a trust environment. The other advantage of a testamentary trust is that any beneficiary of a testamentary trust gets treated like an adult for tax purposes. So, a 1-year-old can get access to the $18,200 tax-free threshold on income that's distributed from a testamentary trust, as opposed to the tax-free threshold that applies when money's distributed from a family trust. I think the threshold there is, it's about $500 odd, so it's pretty minor. So a very powerful tool that a testamentary trust can provide. Superannuation as well, we've just got to balance up there. We'll talk about, or we've sort of touched on, the spouses don't pay death benefits tax. Adult children would typically be subject to death benefits tax. There are some other niche things that may throw a spanner in the works on that, which is a positive thing. But very broadly, that's the way to sort of look at super. The other aspect with super that you've got to consider is the sale of assets in a super fund before the death benefit gets paid out. So that sale of assets is a capital gains event, and that may be subject to capital gains tax. So you've got to obviously consider the fund's ability to pay that tax, and then the ability of whether it's the fund paying any death benefits tax or the estate paying any death benefits tax. Really depends on who the beneficiary is there. So in terms of some key estate considerations, so, specific assets, the value and the tax attached to it. We've spoken about the pre and post CGT assets. We've spoken about, obviously, I use the example of someone inheriting an asset, selling it, using the proceeds to pay off their mortgage. They really need to be conscious of the after-tax value of the asset. And, particularly when we're looking at specific assets, we might have a client who wants to have, property A go to his daughter and property B go to his son. Well, each of those properties might be worth the same amount, but the odds are that they didn't pay the same amount for it. Therefore, the after-tax values are different. So that should be contemplated as well. Non-estate assets, how do we control where they go? So I spoke about that in the context of a family trust with that appointor position. If you have a company that you use to invest through, then those company shares would be owned by someone, and it's the shareholding that you'd look to transfer as well, because like an appointor can hire and fire trustees, a shareholder can hire and fire directors, and it's the control that you're looking at trying to achieve. Strategies to minimise death benefit tax in super. We'll go through a little bit of that on the next couple of slides, perhaps. There's some pretty strategies that TAG likes to discuss with its clients around minimising those taxes. Ultimately, the best way to minimise a tax, I say to clients, well, if you don't want to pay death tax, then take it all out. But that's only as good as what are you going to do with the money outside of super, and you might end up paying income tax while he's still alive on the money while it's held outside of super. So, if you've got someone on the death's door, you talked about it before, Emma, having a plan and understanding, what are the things that we should do if things look pretty dire. That's really important to think about now when you're not in that stressed out state, so that when that time ultimately comes, you've actually got a little bit of clarity about what can be done, and then you can really sort of channel and focus your energies where they need to be. Okay. Divorce and marriage, its impact on wills. So that's an interesting one. So at least in Victoria, marriage invalidates a will unless the will's been made in contemplation of marriage, whereas divorce automatically doesn't impact the will. So, if you've got those significant events going on, then it's obviously probably more from a divorce side of things. You're probably engaging a lawyer around the divorce. The lawyer really should be engaging you then around your will and any changes that need to be made there. The flow on as well, changes to be made to your death benefit nominations in your super fund. Charitable intentions, that's another important one as well. So, we've got a lot of people that want to leave money to charities. It's important to contemplate how that can be done. Charity names change over time. There's, so you're leaving it to charities in the spirit of what can be achieved. Sometimes we say to clients it might be worth giving some of it to charities while you're alive so you can see them enjoy it. But obviously, like a lot of things, once you give it away, it's probably not coming back. So you've got to make sure that you've still got enough to look after yourself while you're still standing upright. I'll hand over to Emma now, who's going to go through a couple of the issues around superannuation specifically.
Thank you. So I'm going to look at now sort of what happens to your super, in the event of your death. Now, we'll focus on the trust deed. So the trust deed is a very critical document. It governs the superannuation fund, and there are certain estate planning matters in there that only the trust deed will advise the members on what they can and can't do. And this is around, binding death benefit nominations, if you've got pensions, if they're reversionary, what takes precedence, all that type of thing. So it actually governs the fund. So it's quite important. You need to make sure, obviously, it's up to date. The law for super is always changing. So making sure you've got the latest, benefits. There's always case law. There's lots of things happening in this sort of area. So you want to make sure that your deed is flexible around these sorts of sets of areas. So you can put in place the estate plan that meets your needs and your wishes. I would suggest, trustees that are sort of older than, probably um, 2015, sorry, earlier than 2012. So maybe the last 10 years should have the latest, things that you can and can't do. So update the deed if that's a factor, because in terms of you binding nominations, you can do all sorts of things with them now. The the SIS legislation, so the superannuation legislation, doesn't apply to binding nominations for a self-managed super fund. So that's why it's quite important for your trust deed to list what you can and can't do. So, in things like your binding death benefit nomination, like it can, pretty much in the past, it would go to your spouse and that's it. But what happens once the spouse goes, or what happens if you go at the same time? So you can now have sort of cascading nominations. So if your spouse dies, then I want it to go to my estate or my kids, or so your wishes are really followed through and bound on the trustees, to the end if various things happen along the way. If you've got pensions in place now, they may or may not be reversionary. A reversionary pension, again, if you look at the deed, but most deeds sort of say that will have, so it automatically reverts to your spouse on death if you've got that in place in the contract when you set up the pension. That will sort of generally, again, according to the trust deed, will take precedence over a death benefit nomination. So you might sort of sit back and say, well, why do I need a death benefit nomination? I've got everything in pension phase. It's really become, more critical since 2017 and the changes. We've got the transfer balance cap. You can only have, now anywhere up to 1.9 million in pension. So if you've got more benefits than that, yeah, you've most likely got, one or multiple pensions up to your cap, and then, potentially a chunk in accumulation. So, reversionary pensions will take care of the pension, but then your binding nomination really would come in and take care of the accumulation side of your benefits there. So still, it's probably there's more importance now since those changes to, look at having both and not just thinking, well, I've got pensions, they'll just automatically go. With reversionary pensions, there's reporting to do with these pensions and going to spouses, and anything to do with in terms of your transfer balance cap. Now, you might receive a pension automatically from your spouse, but you might have maximised your own cap. So, you've got essentially a 12-month window because you obviously can't keep that much in pension phase up to the limit. So there's 12-month window to sort of, rectify the situation. And then there's strategies around that. So, to try and keep much in super, again, it depends on your wishes, but there's things they can do to receive that pension and still keep, as much as possible in super. In terms of any tax to pay, I guess it depends on where the benefit is going. So, as Jason alluded um, you know, to spouse, there's no tax. When a death benefit nomination comes into play and the benefits need to leave super, if it's going through to estate, yes, there's tax. If it's going directly at 15%, on the taxable component. If there is going to kids directly, well, you need to factor in the Medicare levy, or um, on top of that. So generally 17%. So it's good to consider the tax as well because, okay, so the fund might, the fund needs cash. It potentially is, if it doesn't cash up to and just distributes its investment. So, I've seen some situations where, no, I'm not selling this property. I want the kids to get it. So, but, if it's going directly to the kid, there needs to be sufficient cash, depending on the tax components of the member's benefit, because there's death benefits tax. Again, it's leaving super, so there's still capital gains tax. So essentially, we're selling an asset, we're transferring it to the beneficiary ultimately, but it's still essentially in the SMSF's eyes, you're getting rid of that asset in the fund. So, so you've got capital gains tax and potentially death benefits tax. That, how is it going to pay for, who and how is going to pay for this? If it's going to the estate, well, the estate can take care of it and the fund won't need to have liquidity for those types of things. If the property was going directly to, an adult child, well, the super fund then needs the liquidity, especially to pay the death benefits tax and the capital gains tax. So again, there's just additional factors to consider, on transferring assets out of the fund to beneficiaries. Insurances will sort of follow in terms of if it follows the form of the current member's benefits. So I don't think I'll go into too much detail in that one, and it will just flow. If it's a reversionary pension, it will just attach onto that and flow through to the spouse. In terms of SMSF changes, um, especially where we're probably talking here about the structure. So do we need to do a change in trustee? Do we have two individual members that are trustees of the fund that now, due to a death, it leaves only one individual trustee, which we can't have, which fails the SMSF will fail the requirements to be an SMSF because it's a trust. So, we need to restructure at that point. Some people are doing that now because, who wants to deal with that sort of stuff, when you're grieving and that sort of thing. But again, the deed will determine how that will happen. And the other thing, SMSF changes is really also looking at, okay, the proposed $3 million cap. All right, there's still no draft legislation on this matter yet, but you've got two spouses, both comfortably travelling along with it, with both under $3 million in total super, so they're not, subject to the cap and additional tax and that sort of thing. But in the event that their spouse dies and benefits roll to the spouse, then potentially all of a sudden that spouse might be, they might have more than $3 million in super at that point in time. So all of a sudden now they're hit with, potential tax just by receiving that. So just a few, again, we'll wait and see what the fine print says, but just something to be mindful only at this point in time, I think. Okay. Binding death benefit nominations is really a very important document because this is the document that the super fund talks to the will if you want benefits to flow through to your estate in terms of your plan. So the deed will ensure, it will say what format it needs to be in to be valid. It needs to be witnessed by two independent witnesses that shouldn't be parties, or beneficiaries ultimately of your will. It's a legal document. It is binding on the trustee. It's quite important to have this in place. In the absence, I'll just talk about quickly the not having one in place. Essentially, the trustee or your executor and the trustees pretty much have discretion. Again, it comes down to the deed, and the deed would say, well, you've got discretion how to pay this out. And, things can always go terribly wrong. You'd always hope that they wouldn't, but, there's been cases there, this has been the case. But, I mean, they should be, a prudent executor should be considering your wishes, what you want, all of that sort of thing, looking for your beneficiaries and paying it out accordingly. But essentially, I mean, they also could, not pay it out in accordance with your wishes and, take the lot. That's a very extreme example, but, that's something that could happen. So trustee is bound by this, and yeah, it's critical that it's valid. Now, these, again, the deed will state whether they expire or not. Generally, deeds now don't have a time frame, so they will, they're non-lapsing, until you revoke them in the future. So you can sort of set it in place. If things don't change, you don't need to update it every 3 years, and you don't need to be worried, oh God, I've got to get onto that because I'm going away or whatnot. So yeah, so there's nothing around that. The wording, if you're going to the executor, the wording needs to be quite specific to get the right wording. Can't just say per my last will and testament, because again, there's cases out there that have been thrown out and challenged because of the wording. So we need to be quite specific to make sure that things are valid, and it can't be disproved at the end of the day. To make sure your plan goes through how you envisage it. Have I missed anything there on binding death benefit nominations?
No, I think you're right. I mean, the binding death nomination really, to summarise it, I guess, is the will for your superannuation. Yes, you've got a reversionary beneficiary. So, as we spoke, you've got a hierarchy. A reversionary beneficiary or a reversionary nomination will apply to each pension. Okay, so just because you've got a reversionary nomination on one pension, commonly we see people that might run multiple pensions out of a superannuation fund. So you need to make sure that all those pensions are reversionary, if that's your wishes. Whereas a binding nomination will then apply to anything that doesn't have a reversionary nomination in place. So that's sort of really important. And as you said, Emma, I mean, there's been substantial case law. Naturally enough, as I said at the top, superannuation next to the family home is what a majority of the country have as their two main assets. So disputes around or disputes involving superannuation continually happen because there's obviously more wealth within superannuation now than ever before. So making sure the death benefit nominations are up to date. Again, we talked about divorce and marriage, making sure you have those life circumstances, make sure they're up to date as well. Yes, there's a lot of flexibility from them. That more recent deeds allow your fund to be able to apply, but just because it's flexible, take you back again to the start, make sure it's easy to administer. Flexibility, you use that example with the property or the asset distributed through, don't sell it at any cost, but there's obviously a tax hit depending on certain beneficiaries, so that's really important to consider as well. In terms of some common questions, before we sort of wrap it up. So, I mean, really what we've got for the most common questions, the things that we see often is that, how do we ensure my child's partner can't get hold of my wealth? So, again, a lot of people, you've worked hard to grow your wealth. You want your wealth to go to the right people. You don't want your wealth to fall into the wrong hands. So, testamentary trusts are great to protect wealth from things like creditors. So, whether that's because you've got a child or a beneficiary who's got financial difficulties, protecting the assets in a testamentary trust are really vital. They may have litigation difficulties or risks because of their profession. Again, trust is really important. The one thing that testamentary trusts can't necessarily fully protect against is the family court. So the family court can get their hands on whatever they want, more or less, whenever they want it. But what they do recognise, though, is that what goes into a testamentary trust is really coming from someone who's passed away. And so as far as a husband and wife go, or a couple go, that's going in through a family court issue, a couple can't go to a court going, we've contributed these assets to a testamentary trust, because one of them will be dead if that's the case. So, so courts really do look at testamentary trusts as part of the wealth, but not necessarily part of the divisible assets. So that's an important thing to consider. As far as the child's partner goes, testamentary trusts again are good as well, are good vehicles to help protect if you've got a beneficiary who you're concerned with. So they may have, a drug and alcohol, a gambling problem, those sorts of things. They may just be too young. So you can add some certain stipulations there that sort of restrict their ability to use all the wealth that goes in there at certain times. So They do carry a lot of ability and flexibility. Again, just make sure you're balancing that up with ease of administration. Pre-death distributions, I used the example with charities before, but, people often help out their children. It might be commonly to help them buy a home, those sorts of things. If you're just gifting money to one child, well, then the money's more or less gone. If you're loaning money to children, then at least you've got some sort of documentation that can tie that wealth back to you. Again, in the event of a marital split, that's really important. One thing I'd say with that, though, is if you're giving it to one child but not the others, you've really got to make sure that you're trying to acknowledge and balance these things up in your will. You might have children. You might have a child who's 32 and one that's 22, and the 32-year-old wants to buy a property and the 22-year-old's far from it. So, children are, beneficiaries have all got their own lives, they've got their own complexities, they've got their own details. So you've got to obviously acknowledge and recognize that, how you help your children at different times and for different circumstances will differ amongst all your kids. But just making sure that you're contemplating how that gets reflected in a will is really important as well. When it comes to things like loans and loans for homes, one thing obviously you've got to watch out for is, you probably don't have an ability to register a mortgage on a title, because they're probably still going to need to involve a bank. So that may complicate their ability to secure finance from a bank as well. So it's got to be balanced up and thought of. When I spoke about the pre-death distributions, yeah, you're helping those kids out, but if you help them out and then you can't do anything with your lives, then I don't necessarily think that that's the best decision to make. But you've got to make, obviously that's a horses for courses decision, make that decision on your own, and make sure that you're contemplating that. As I said, you might still have a lot of years left, so don't leave yourself short in later years. That they're probably the common questions we've got. The family court is really the big one. The pre-death distributions, we see that a lot. Sometimes people that sort of have got very comfortably wealthy, we talk about, do you make those pre-death distributions, or at least in part to some of the beneficiaries? Because wouldn't it be great to see them get some enjoyment out of it? You can have the comfort that they're going to enjoy it when you're gone, but wouldn't it be great to see them enjoy some of it along the way? So that's a really common emotion to have, but again, it just needs to be balanced and thought through. Sometimes what we find clients do is, we've got our investment advisory team. What they, one of the services they offer is, sort of projections, making sure that they can project your wealth, project your cash flow, and that can be, a really good service to sort of consider when you're considering pre-death distributions, because it might give you some comfort to know that, what you're looking to do can be achieved, or maybe it's best not to try and do it. So again, just having that knowledge is powerful in your hands. So look, in the absence of any other questions as we go, look, how can TAG help? Just email us through the team at tag@tagfinancial.com.au, or call us on that number. More than happy to have a complimentary meeting. Either Emma or myself or one of the other partners or managers here happy to help. It really is important, as I said at the start, formulate a plan, think with the end in mind. It really should go very similarly to how your investment philosophy works, because you should have a plan or an objective, and then you should invest with that objective. You should have an objective on how you want your wealth to go once you're gone, and then execute that plan via a will to make sure that can be achieved. So if you've got any questions, you've got any concerns, give us a call. Happy to have that complimentary meeting and help you achieve your estate planning wishes. So that's all we've got time for today. Thanks, Emma, for your time, and thank you all for listening, and we'll see you again soon.
Thank you.